5 seconds to go. Start. Under Regulation 23 of the DCR for Greater Bombay 1991, open space is to be provided in fact for any layout starting from 1001 square meters to 2500 square meters wherein 15% is to be kept as open space. For an area of 2501 square meters to 10,000 square meters, 20% has to be kept as open space. In the case of residential and commercial layout for area above 10,000 square meters, 25% has to be maintained as open space. There are certain exceptions. The ownership, no doubt, is to vest by a deed of conveyance in all the property owners on account of whose holdings the recreational space is assigned. It also appears to provide that the remaining area of recreational open space or playground, that is after excluding structures providing for pavilions, gymnasium, clubhouses, etc., is to be made accessible to all members as a place of recreation, garden or playground. The words communal and recreational purpose for which the OSR area is to be used in the case of the impugned rule regulation appears to indicate that the word communal is to be given a meaning which would be in keeping with the object of law, enable members of the public as well to gain access when the layout is more than 10,000 square meters. In this regard, even in Pandit Chetram Supra, we recapture the following. Reserving any site for any street, open space, park, school, etc. in a layout plan is normally a public purpose as it is inherent in such reservation that it shall be used by the public in general. The effect of such reservation is that the owner ceases to be a legal owner of the land in dispute and he holds the land for the benefit of the society or the public in general. It may result in creating an obligation in nature of trust and may preclude the owner from transferring or selling his interest in it. It may be true, as held by the High Court, that the interest which is left in the owner is a residuary interest which may be nothing more than a right to hold this land in trust for the specific purpose specified by the colonizer in the sanctioned layout plan. But the question is, does it entitle the corporation to claim that the land so specified should be transferred to the authority free of cost? That is not made out from any provision in the Act or on any principle of law. Rule 61(7) of the Andhra Pradesh rules in Andhra Pradesh, which we have referred to, is unambiguous that the area used as greenery shall be accessible to the entire community. It is to be secured by means of the gift contemplated in Rule 6140. While we cannot be sitting in judgment over the said rule, we would think that the purport of the impugned rule regulation must be understood as persuading the court to not place a narrow interpretation. In this regard, we find reassurance in the view taken by the courts in the United States, even in the presence of the taking clause under the Fifth Amendment to the US Constitution. In an article titled Techniques for Preserving Open Space, we find the following. A municipality can require the developer of a new subdivision to provide such facilities as roads, streets, sewers, and playgrounds as a condition to plat approval. In the leading case of Aris versus City Council, a requirement that the subdivider dedicate land for road and street purposes and leave undeveloped an accompanying area for trees and shrubbery was approved on the theory. Stop.